Assalamu alaikum and welcome to the free legal advice show on British Muslim TV. I'm your host Ilyas Bulbulia and I'll be with you for the next hour. As our regular viewers are aware, the free legal advice show provides you, our viewers, the opportunity to call in and ask us any questions that you have on any aspect of English law. On this show, I should be able to cover a vast, diverse range of matters ranging from immigration law matters, family law matters, criminal law matters. So whatever your legal questions are, please feel free to ring on the number that appears at the bottom of the screen. The number that you can call on is the landline number. Alternatively, if you want to send me a message, a WhatsApp message or a text message, you can do so on the mobile number that appears at the bottom of the screen. A couple of minor points before we get going. Obviously, on a live show, it's not possible to take very detailed information from callers who call in. If it transpires that your matter is quite complex, or if it transpires that I need to look at your documents before I can advise you properly, then I will ask you to leave your number with the control room and I will try and call you back off air and we can have that more thorough discussion off air after I've had a more detailed discussion with you or after I've looked at your documents. As always, it's a free legal advice show. The advice that we provide is completely free of charge. And if I need to speak to you after the show because I need to look at your documents or I need to have more in-depth conversations with you, again, that's absolutely free of charge as well. So 2 ways to contact us: landline number to speak to me directly or on air. Alternatively, if matters are confidential, you don't feel comfortable to come on air, then absolutely fine. You can send us a message on the mobile number, which also appears at the bottom of the screen. As always, we have a number of WhatsApp questions coming in already, which is fantastic. Please do keep on sending your messages in and I will try and answer all the questions that you do send in. So we've got a number of questions that have come in, but we have a caller who's waiting to speak to us live on air. So let's take our first call for the day. Hello, Assalamu alaikum.
Wa alaikum assalam. मेरा ये क्वेश्चन है कि पाकिस्तान से वर्क परमिट आदमी मंगवाना उसका क्या प्रोसेस है
जी, और
दूसरा नंबर में एमएसटी के बारे में मालूम करना था कि उसका कोई नया कानून आया है या नहीं आया।
एक जो क्वेश्चन है आपका वर्क परमिट के बारे में है ना, एंड सेकंड क्वेश्चन आपने क्या कहा, किसके बारे में है? सेकंड एमनेस्टी। जी जी जी, ठीक है, एमनेस्टी के बारे में ना, ठीक है। Amnesty. So brother is asking 2 questions, a caller from Dewsbury. First question relates to the system for work permit and the second question relates to amnesty and whether that's coming in or not. ना, ठीक है भाई, जज़ाकल्लाह आपका कॉल के लिए। मैं अभी आंसर करता हूँ वो आपका क्वेश्चन।
Thank you very much.
Thank you very much indeed. Okay. So the 2 questions relate to work permit and amnesty. To be quite honest, both are quite topical questions. Work permit is quite topical at the moment because the new work permit scheme came in January 2021. So a lot of people are asking questions for that. It is possible to come to the UK under the skilled worker visa, which is sometimes still referred to as the work permit visa. In essence, in order to come to the UK under the skilled worker visa, you do need a sponsor in the United Kingdom. So there has to be a business which sponsors you to come to the United Kingdom. And as long as you are coming to do skilled work and you are able to speak English, read and write English at a reasonable standard, you are able to apply for a skilled worker visa. But the key thing here is that you can't come to look for work. It has to be a business in the UK registered with the Home Office that's willing to sponsor you. So the key point is, if you are interested in the work permit scheme, the skilled worker scheme, the key point is it has to be a business in the UK that's willing to sponsor you. So that's the position with the work permit or the skilled worker visa. The second question that our brother was asking about was to do with the amnesty. Again, in practice, you get asked about amnesty. Is there an amnesty come in? What will any amnesty that comes in, what will it look like? What will the requirements be that need to be fulfilled to qualify under the amnesty scheme? The reality is, at the moment, there is no proposal to introduce an amnesty for those who have overstayed. If the caller is still online, let's see whether we can ask the caller some questions. भाई साहब अभी आप लाइन पे ही है?
जी जी जी
जी, तो मैंने जो कहा ना कि amnesty के बारे में, अभी तो amnesty की पहले 2-3 साल पहले उसने amnesty की बात की थी गवर्नमेंट ने, मगर amnesty के बारे में 1-2 साल के बाद 1-2 साल में फिर और कोई बात उसने नहीं की, क्योंकि वो कोविड आ गया और इसके बाद वो ब्रेक्सिट भी था. तो ये दोनों चीज़ हुई ना, ब्रेक्सिट एंड कोविड. सो इसमें क्या हुआ कि amnesty की जो पहले बात हुई थी तो बिल्कुल amnesty के बारे में वो क्वाइट हो गए. तो जो amnesty के बारे में आप पूछ रहे हैं, तो जो ओवरस्टे किया है वो कितने साल से ओवरस्टे किया है?
उसने कम से कम 12-13 साल हो गए.
12-13 years. ऑलराइट, ओके. सो आपको तो याद होगा कि पहले एक स्कीम थी कि 14 years के बाद वो परमानेंट देते थे, वो तो उसने निकाल दिया है. सो अभी जो सिचुएशन है ना, जो बंदा सिंगल है तो उसको 20 years वेट करना पड़ता है. अभी 20 years के बाद उसको वीज़ा मिल सकती है, 20 years के बाद. मगर amnesty की जो आपने बात की ना, तो अभी तो कोई amnesty की स्कीम नहीं है. हो सकता है कि वो लाएंगे, मगर एट द मोमेंट तो amnesty की बिल्कुल प्रपोजल नहीं है. तो अगर कोई बंदा यहाँ है, उसने ओवरस्टे किया है, तो अभी एप्लीकेशन डालने में कोई फ़ायदा तो नहीं है, क्योंकि वो सिर्फ क्या कहेंगे कि वो सिंगल बंदा है, उसका 20 years यूके में नहीं हुए हैं, तो उस बेसिस पे उसका वीज़ा एप्लीकेशन वो रिफ्यूज़ कर देगा. अगर उसका सिचुएशन डिफरेंट है, फॉर एग्जांपल उसके पास फैमिली है, चिल्ड्रन है, तो वो सिचुएशन डिफरेंट है. मगर सिंगल पर्सन के लिए जो अगर उसने एप्लीकेशन 20 साल से पहले डाला, तो वो तो रिफ्यूज़ ही करेंगे वो.
ओके. अच्छा, एक मेरी ये बात है कि एक आदमी है, उसके पास एक बच्चा भी है, तो अभी वो डाले, उसका वीज़ा लग जाएगा?
हाँ, जिसके पास बच्चा है ना, उसके पास थोड़े से ज़्यादा चांस होते हैं. सो बच्चे के बारे में उसका रूल ये है कि अगर बच्चा ब्रिटिश है तो वो अप्लाई स्ट्रेट अवे कर सकता है. अगर बच्चा ब्रिटिश नहीं है, क्योंकि मदर फादर दोनों फॉरेन नेशनल्स है, तो अगर बच्चा
जो है वो ब्रिटिश है, बोर्न इस कंट्री का है
जी, तो अगर बच्चा जो है ना वो ब्रिटिश है और बच्चे उसके साथ रहता है, या तो वो बच्चे के साथ सेपरेट है मगर बच्चे से मिलता है, तो उस बेसिस वो गारंटीड अप्लाई कर सकता है. जी, अभी कर सकता है अप्लाई.
ओके 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 ओके.
सो इसमें ये सिचुएशन है कि बच्चा जब ब्रिटिश होता है तो आप स्ट्रेट अवे अप्लाई कर सकते हैं बच्चे के बेसिस पे. अगर बच्चा ब्रिटिश नहीं है तो फिर वेट करना पड़ता है. जब बच्चे का यूके में 7 साल जब हो जाएंगे, उसके बाद अप्लाई करें. सो इस पे डिपेंड, बच्चे के स्टेटस पे डिपेंड होता है. ब्रिटिश के लिए डिफरेंट है और नॉन ब्रिटिश चाइल्ड के लिए डिफरेंट है.
ओके, ठीक हो गया. बच्चा ब्रिटिश है यानी वो ब्रिटिश स्टेट में अप्लाई कर सकता है?
जी, अगर बच्चा ब्रिटिश है तो स्ट्रेट अवे. इसमें ये सिर्फ बताना पड़ता है कि बच्चा उसके साथ रहता है जो अप्लाई कर रहा है, या तो अगर उसके साथ नहीं है क्योंकि वो पेरेंट्स सेपरेट रह रहे हैं, तो फिर ये बताना पड़ता है कि बच्चे के साथ उसका कॉन्टैक्ट है. सो साथ में होना चाहिए या तो कॉन्टैक्ट होना चाहिए, तो वो बच्चे के बेसिस पे वो वीज़ा दे सकते हैं और वो फ़ौरन अप्लाई कर सकते हैं. इसमें वेट करने की ज़रूरत नहीं है.
ओके, थैंक यू वेरी मच इलियास भाई.
जी, जज़ाकल्लाह आपके कॉल के लिए. थैंक यू वेरी मच.
बहुत बहुत मेहरबानी. थैंक यू वेरी मच.
थैंक यू वेरी मच. ओके, थैंक यू. जज़ाकल्लाह आपके कॉल के लिए. Thank you very much. Okay, Hafiz. So the call was twofold. One was to do with the work permit. The other was to do with whether there's an amnesty coming in. But in respect of the amnesty, when we discussed the matter in more detail, the caller explained that the person who is currently in the UK and has overstayed does actually have a child who's British. So the person who's overstayed must have a partner who's British or must have a partner who has indefinite leave to remain. And as a result, the child from the relationship is British. Now, as I explained, somebody who's overstayed in the United Kingdom, whether they have overstayed for a year, 2 years, 5 years, whatever it is, the duration, once they have a child in the UK that is British, that does mean that there is a possibility of applying for leave to remain based on the child that's British. Now, obviously, if the application is based on the child that's British, you have to demonstrate that either the child lives with you or you have to demonstrate that if the child doesn't live with you, you have regular contact with the child. Because it's understandable, it's common sense, isn't it? Where if you're applying for leave to remain based on a British child, then obviously there has to be a relationship, a parental relationship with the child. You're either living with the child, looking after the child, or you're regularly seeing the child. You've got contact access in terms of the British child. So it's understandable that if you're an overstayer and you want to apply on the basis of your British child, you must be with the child living, or you have contact with the child. So that's the situation. And I also explained that if there is a child from a relationship here, but the child is not British, and the child does not have indefinite leave to remain, then the position is slightly different, slightly more complicated. In those circumstances, normally what is required is, if the application is going to be based on the child, then normally what's required is for the child to have lived in the UK. So it's the child's been in the UK for 7 years. If the child's been living in the UK for 7 years, the Home Office will hopefully take the view that it's unreasonable to expect the child to leave the UK. And it's on that basis that the person who's overstayed can stay in the UK. So it's straightforward when the child is British. When the child isn't British, doesn't have indefinite leave to remain, the child's residence in the UK normally has to be around the 7-year mark. So that's the basic position with somebody who has overstayed in the United Kingdom. And in answer to the specific question, and I get asked this question quite regularly, is there an amnesty coming in? At the moment, unfortunately, there is no amnesty proposed. Situation could change, and absolutely, if such a scheme is to come in, we will go through that in great detail on this show. Taking a short break, we'll be back in the next couple of minutes. Assalamu alaikum and welcome back to the free legal advice show on British Muslim TV. To speak to me live on air, please ring on the landline number that appears at the bottom of the screen. Alternatively, as always, you can send me a message. If you don't want to speak to me live on air, matters are confidential or sensitive, please feel free to send a message in on the mobile number that appears at the bottom of the screen. So to speak to me live, it is the landline number, and to send me a message, a WhatsApp message or a text message, it's the mobile number that appears at the bottom of the screen. I will receive your message here and I will be able to answer your message live on air. We've had a number of WhatsApp messages coming in. Let's try and deal with some of those that have come in. The next one that's come in, it's quite a long message. Let me read the question out as it's been sent in, and then let's break it down and go through it and see where we are. So the question looks like a family law related question, which is absolutely fine. We get numerous questions on immigration law, but if your matter relates to other legal matters, family law, criminal law matters, etc., please do feel free to send those questions in as well. Now, the question is this. Family law question. My ex-wife left me and our children in 2016. There are 3 children. 2 of the children were aged 12 and 14 at the time. We have a property in joint names, which myself and the children live in. She never worked. I solely paid the mortgage since we bought the house, and I'm still paying the mortgage to date. She now wants 50% of the property. I've been paying the mortgage payments. I've paid for the improvements in the house as well. Now she wants 50% of the property. Now, the reality is, if you are married, she will be able to make some kind of financial claim. But the key thing here is, if the children are with you, it's highly unlikely that she will get 50% of the house. It's going to be a much lesser sum because you have children under the age of 18 living with you. It could be that she's only entitled to something in the region of 25 to 30%. I'll look at this in greater detail after I've taken the next call. Hello, assalamu alaikum. Hello.
Yes, hello.
Hello, hi. Assalamu alaikum. What's your question, please?
Basically, I just needed to ask, are there still currently delays in the Home Office in regards to applications? We made application FLRFP this year and just wanted to know, are they still facing a backlog and are there delays?
Okay. In terms of the application FLRFP, when was it made? Do you know the month when the biometrics were done, the fingerprints were taken?
The fingerprints were taken in March.
Is it March of this year?
Yes.
Yeah. And in terms of the FLRFP application, is it an application being made for the first time, or is it like an extension application?
This is an extension application.
An extension application. All right. Okay. Now, in terms of processing, most applications are now processed within about 3 to 4 months. There isn't much of a delay now like we had last year. So most applications are processed within 3 to 4 months of the date the fingerprints are taken. So if the fingerprints were done in March, let's say, for example, mid-March, April, May, June, you're looking at a decision around mid to the end of June. Now, FLRFP applications generally are the ones which take the longest to be decided. However, there isn't a real delay at the moment. And secondly, this is going to be fairly straightforward because it's simply an extension application. It's not a new application. I would work on the basis that you get a decision around the end of June, hopefully.
Okay, so will that still differ if biometrics were given? The biometrics were done 28th of March and application was submitted 28th of February.
Sorry, I do apologize. Sorry, if you just repeat the question again, sorry.
So, you know, the application was submitted 28th of February and the biometrics were done 28th of March. So are you saying that around end of June is probably when we will get?
Yeah, because what you don't look at is the date the application is made. You don't look at that because the Home Office won't start looking at the application until the biometrics are enrolled. So to some extent, you lose that time. You really need to count the processing time from the date the biometrics are enrolled, which is from the end of March. So earliest would be end of June. If we hit processing, if there's a slight delay, it might just go over to July.
Okay, that's perfectly fine. Thank you so much.
Brilliant. No problem at all. Thank you very much for your call. Thank
you.
Bye. Thank you. Bye. So just a basic question regarding processing. In my experience at the moment, processing of applications seems to be back on track. There were significant delays last year, people waiting 10 months for applications to be processed. But at the moment, we seem to be back on track. 3, possibly 4 months for a decision on a straightforward case. Okay. Now, just before I took that call, we were looking at the question, it's a family law question, where our viewer had sent in quite a detailed WhatsApp message about husband and wife split up. The husband, who's actually sent the message in, saying that there were 3 children, 2 were 12 and 14 at the time. Now, the issue is, if the property is split, how will it be split? The position basically is this, that what the court does look at is, at the time you deal with the financial aspects of the divorce, they do look at how many children are under the age of 18. Now, appreciate it was 5 years ago, so some of the children are growing up. That's the problem. At the time that the separation took place, the children were all under 18, I suspect. The slight difficulty here is some of the children are growing up very close to the age at which they become adults. That will have an impact on the way the assets are split between the parties. generally speaking, if there are children under the age of 18, then the parent with whom the children live generally that parent will normally get a bigger share of the assets. So if it's a house and if it's split, the parent with the children normally gets, let's say, for example, 70% of the asset, and the parent that doesn't have the children gets the lesser percentage. Slight difficulty here, as I see it, is that the children seem to be getting close to the date when they're going to reach 18. The problem is, in that situation, it may be that the court looks at a 50-50 split. Now, I appreciate what you're saying in terms of you bringing the children up, you paying the mortgage, etc. And that is something that will be taken into account. But the biggest factor normally when the matrimonial home has to be split up, the biggest factor that's looked at is really what the position of the children is, the children under the age of 18. So the party with whom the children are living normally will get the bigger share. If the children are over the age of 18, obviously that's less relevant, and it becomes more likely that the split is more around the 50-50 mark. So without knowing greater detail, that's the basic position. I mean, as far as you're concerned, if the property is split, whilst the children are under the age of 18, it will be more advantageous for you. Let's take the next call. We've got have a caller online. Hello, assalamu alaikum. Thank you for calling. What's your question?
Actually, I have a question about, I'm coming from here, from spouse visa.
Okay.
I have 5 years complete now, so I'm going to apply for the permanent.
Okay, I understand. Yep.
Okay, permanent. So what I need to do, which documents I need?
Okay, all right. When does your visa expire?
My visa going to expire September.
September, all right, okay. So you've got a few months left now. In terms of when you came to the United Kingdom, roughly which month and year did you come to the United Kingdom?
Actually, I came here 2016, 21 May. So I've completed 5 years. So I have planned, I'm going to apply for visa now.
All right, that's what I was trying to get at. That if you have completed your 5 years, you can actually apply now. Now, if I explain this in very simple terms, there are 3 things that you will need to demonstrate, generally speaking. One is English, which hopefully isn't a problem for you. Your English is very fluent. So in terms of the English requirement, you need to do the Life in the UK test and the B1 test in English.
Yes.
So
I did by B1 already, and I got as well the Life in UK.
All right, okay. So that's the English requirement dealt with. The second requirement is the financial requirement. Are you employed or self-employed? Sorry, are you employed or self-employed?
No, actually I'm working for somewhere.
Okay, all right, so you're employed, yeah? So normally you'd need to submit, in a normal case, you submit 6 months of wage slips.
All right.
6 months of bank statements.
Okay.
And a recent employment letter confirming that you're employed, how much you're earning, what your job title is, etc.
Can I send the P60? Is it all right for me?
You can, but it's not mandatory. In terms of finances, what's mandatory is your wage slips, 6 months, your bank statements, 6 months, and the employment letter. You can send your P60 in, you can send your contract in as well, but the P60 and the contract, they're not mandatory. It's the wage slips, bank statements, and the employment letter. So in terms of your income, very roughly, how much do you earn?
For probably is all right. Is more than requirement.
Fantastic. Okay, so you need to be careful. So 6 months of wage slip, 6 months of bank statements, and the employment letter.
Yeah.
Now the third thing, the easiest of them all, you need to obviously demonstrate you're still living with your wife. So for the years 2019, 20 and 21, just submit a selection of letters and bills, 2-3 letters and bills in your name, 2-3 letters and bills in your wife's name for 19, 20 and 2021, just at the same address, just to show that you're living together. So key thing is English, income, and demonstrating your relationship. In essence, They're the three things you need to get right. But, I mean, by the sounds of it, you've got it all sorted anyway.
But, I need to confirm one thing more. You know that if we're going to apply the online, we have planned, we're going to do ourselves.
Okay. What I'll do is we are shortly going to be taking a break. We'll be back in the next couple of minutes. If you hold on, we'll look at it then. I'll see you in a few minutes. Assalamu alaikum and welcome back to the Free Legal Advice Show on British Muslim TV. I'm your host Ilyas Bulbulia. To speak to me live, please do call on the landline number. And as always, you can send me a message on the mobile number that appears at the bottom of the screen. Just before we went for our break, we had a caller online asking questions about a spouse application. In particular, he's at the indefinite leave to remain stage. So we looked at the kind of requirements that need to be fulfilled when you apply for indefinite leave to remain in the United Kingdom. Hopefully the caller's still there. So let's go back to our caller. I think our caller has a couple more questions. Hello, assalamu alaikum. Hello.
Hello, assalamu alaikum.
Ji walaikum salam. Sorry, we had to take a break, so I had to cut you short.
Yeah, it's all right, no problem.
Yeah, no problem. I think you were asking about the online form just before we went for the break.
Yeah. So I just need to know, you know, there's if you're going to apply the online, you see the lot of page over there. Which one is exactly, you know, the government side?
I understand.
What's the link?
All right. So what you need to do is, and this is what I do, if you go onto Google, and what you need to put in is set M, S for sugar, E for elephant, S for sugar, E for elephant, T for tango, T for tango, set. And then in brackets, open brackets, M for mother, and then close brackets.
And after M?
Yeah, so then set, then open brackets, then M for mother, and then close brackets. So if you put in Google, set M and application form, the first link that comes up should be the actual form. So if you do that, you just obviously need to make sure that the link is a government website. So if you look at what comes up, it will say gov.uk. But if you do that, it will take you to the right form. So it is set M. You don't need to go to any of the forms. That will take you directly to the correct form.
Okay. Let me repeat. S for...
the fee, did you say, sorry?
Sorry. S for summer.
Yeah.
T for elephant. T for turn.
Tango? Yeah. Tree?
Tangle.
Yeah. And then M for mother.
M for mother.
Yeah. When you go onto the website, just make sure when you look at the website address that it does say gov.uk on it, just to be on the safe side. But that should, the first hit on Google should be to that particular form.
All right.
Okay.
All right, sir. Thank you very much.
Thank you very much. Thank you very much for your call. And best of luck with your application. Thank you.
Bye-bye.
Bye. Okay, I think we might still have another caller who's been waiting for a while. Let's see whether the caller is still there. Hello, assalamu alaikum.
Hello, assalamu alaikum. How are you?
Alhamdulillah, good. How are you? You okay?
Alhamdulillah. I have a question to you. I have a parents back there in Pakistan.
Okay.
They are both aged. One father is around 80 years old, and mother is 75 years old.
Okay.
And me and my brother here is for last 20 years old. I'm here for like 9 or 10 years now.
Okay.
We had decent income coming in.
Okay.
Just wanted to know what is the right time to call them up. We want them to be here with us for indefinite.
Okay.
They have been coming here for last 25 years. I mean, on a visit visa for 2 years, 5 years, 6 months, without any issues.
Okay.
But now this is where the age factor is there. There is no one back there to look after them. And we would like your expert views, how we can sponsor them.
Okay.
What are the key areas? What things that we look at so that our application won't get penalized? Because I have a doubt that if they don't meet the criteria, for indefinite leave to remain here in the UK, then their visit visa come into the spotlight, and then they can reject that. So they look into the intentions, whether you want to stay or not. So far, whenever they pay a visit, they usually come for four months, and they went back, and then they normally comes up. If you can just put the highlight your views, how to go about it, and if I can have your private number.
Yeah. If you leave your number, no problem at all. If you leave your number with the control room, or you can ask the control room for my number, that's not a problem. Now, looking at your situation here, I know you've been here for a long time, and you and your brother both settled in the United Kingdom financially, absolutely fine. I'm assuming you're both British citizens, not European nationals. Is that right?
That is indeed correct. We are both British nationals.
Okay, all right.
I have a daughter of mine.
Now, and just to make sure that I've not missed anything, in terms of your partners, your spouses, are they both British as well, not European nationals?
They are both British nationals as well.
All right, okay. And the reason I ask that is this, that if either of you had a European passport, or either of your partners had a European passport, it would have been so easy to sponsor your parents to come to the United Kingdom on a permanent basis. It's unbelievably easy to do it, where either you or your partner has a European passport. The problem is, if we don't fall within the European category, and we're governed by UK immigration rules, it's virtually impossible, in my view, at the moment, to get a visa which leads to permanent settlement in the United Kingdom. Because what we have at the moment for parents is a category which is called the adult dependent relative category. So on the face of it, there is a category there in order to sponsor your parents to come to the UK to live here on a permanent basis. The problem is that there is a requirement there which is essentially says that if your parents are so unwell that they need personal care, then you'll be able to sponsor them to come to the UK if, and this is where the problem is, if personal care is not available in the country where they live. Now, the problem is most countries, India, Pakistan, Middle East, will have a system whereby there are care homes, there are nursing care facilities. And because care facilities exist in the country where parents are, that's enough of a reason to refuse the application. That's the biggest problem at the moment. There is a category, but nobody qualifies under the category. Now, the problem is Europeans have it easy. British nationals are stuck with the UK immigration rules. Prior to summer 2012, it was easy to sponsor parents to come to the UK to live here permanently. Conservative government came in. Summer 2012, one of the things that they introduced was they removed that category under which parents could come, and they introduced this adult dependent relative category, which is virtually impossible to fulfill. I mean, it's so difficult that I would say it's not even worth making the application. What I would say is that you're better off getting your parents a longer term visitor visa. So if they've been coming for many years, maybe get a 5-year visitor visa, get a 10-year visitor visa. So they come 4 or 5 months, go back, stay in their home country, come back again and stay for 4 or 5 months. You're better using the visitor route than applying under. It's absolutely no point. The fee for the application is £3,000 each. I don't think the fee is even a problem. It's just, it's impossible to fulfill. You have to demonstrate that there is no care facility. There are no care facilities in the country where they live. But that's impossible to.
That's possible to do so on my end.
Because all they do is the Home Office, all they do is they go onto Google. And let's say, for example, parents are coming from Islamabad. So they'll put Islamabad nursing care facilities. And although generally don't use nursing care facilities, they do exist. And on Google, we'll show how many facilities there are, care homes, nursing staff available to provide care in the person's home. So the facilities and the service exists in most countries. That's enough for the application to be refused. This is the problem. So I'm afraid it's not good news. I'm not giving you good news, but my view is, look, don't try the I wouldn't try the application. I would simply continue to use the visitor route for the parents to come here. Now, I'm not saying you should do this, but let's say parents continue to come here. If when they're here and they fall ill, they're not able to go back, you could look at taking advice at that stage as to what you could do whilst they're here. You know, but to make the adult dependent relative application from abroad is likely to be refused, and it's likely to have a negative impact on any future visitor application. So I wouldn't try that. If they're here, if they fall ill, we could possibly look at what can be done from here. It's still difficult, but you're better off looking at it that way around than your parents making the application from abroad and jeopardizing their good immigration history.
Yeah, no, makes totally sense. Thank you very much for your time and time.
No problem at all. Thank you very much for your call. Thank you very much indeed.
Okay.
Thank you very much. Yeah, Jazakallah. Thank you for your call. Now, interesting question. We get asked the question quite a lot. Obviously, it's a very common situation where the children, in this case, the brothers are here in the United Kingdom. You get many situations where the whole family is here and it's only the parents who are abroad. Naturally, the children are thinking about, as the parents are getting older, need help as they're getting older. Naturally, the family is looking at what can be done to try and bring the parents here on a more permanent basis. The bad news is that it's a very, very difficult application to make. Prior to summer 2012, there was a specific category which allowed children here to sponsor their parents to come to the UK as long as they were over the age of 65 and financially dependent on the children in the UK. That's been removed. Now, the key problem is that what they now look at is if you're here in the UK and your parents need care, the only situation in which they will be granted a visa is if care facilities are not available in their own home country, which I haven't come across yet, an application, a country where care facilities are not available. Now, I'm not sure about the statistics at the moment offhand, but as I understand it, the adult dependent relative category, in terms of successful applications, we're literally talking about in a year from around the world. I think we're looking at 20, 30 successful applications from around the world in a year. So that just demonstrates that, you know, how difficult it is to qualify under this category. We're going to be taking a short break. We'll be back in the next couple of minutes. We'll look at these questions in greater detail then. Assalamu alaikum and welcome back to the Free Legal Advice Show on British Muslim TV. I'm your host, Ilyas Bulbulia. To speak to me live, please call on the landline number that appears at the bottom of the screen. Alternatively, as always, you can send me a message on the mobile number that appears at the bottom of the screen. Okay, we have a caller who's been waiting for a while. Let's go to that caller. Hello, assalamu alaikum.
Yes, assalamu alaikum. Sir, my name is Saqib.
Yeah, thank you, brother, for calling. What's your question?
Okay, basically, sir, my question is, my appeal is refused in first tribunal.
Okay.
And then I appeal to first tribunal to upper tribunal, and they grant me permission of appeal all grounds.
Okay.
So now I'm going. I already done on appeal to upper tribunal. So my question is, how long it take time to upper tribunal to hearing or like that?
Okay. What kind of case was it then that was refused? What kind of application were you appealing initially?
Is my case asylum, sir?
Asylum. Okay. So the asylum application was refused by the first tier tribunal. You've appealed and the upper tribunal has given permission. So was there a full hearing at the upper tribunal? So I'm just trying to work out where you are at the moment You know, when you're saying that permission has been granted, was it a hearing and permission was granted, or just how did you get permission from the upper tribunal?
No, basically, the first tribunal is refused my case, okay?
Okay.
And I appeal on first tribunal to give me permission to appeal to upper tribunal.
I understand. Yeah. Okay.
So they give me permission, they grant me permission of appeal to all grounds.
Okay. All right. Okay. So have you had
a question?
all right. So you're waiting for the upper tribunal hearing at the moment.
Yeah.
Now, in terms of time frame, there is a delay at the moment in getting before the upper tribunal. The difficulty is how long is it likely to be? My view is that work on the basis that it could well take 4, 5, 6 months to get a hearing in the upper tribunal.
Okay.
I think that's the basis upon which you should be working, that it's going to take a while to get to the upper tribunal. Now, at the moment, a lot of upper tribunal hearings are taking place by video link, which is fantastic. But even then, my experience is that the tribunal system has only really started going again in the last few months in terms of video links, etc. So there is a backlog there. You know, the backlog that was created last year from around March 2020 to sort of the end of 2020, those 6 months where people didn't really know what was going on, systems weren't really in place to progress things. So that created a bit of a backlog in the tribunal system. So obviously your case goes in the queue, and it's at the back of the queue at the moment, but work on the basis that it could easily take 4, 5, 6 months before there's an upper tribunal hearing, unfortunately. There isn't much you can do. You're just simply going to have to sit it out and wait, I'm afraid. But thank you very much for your call. And as always, we get numerous questions on delay, whether it's a question on delay before the, in terms of applications being processed by the Home Office, or delays in the tribunal system. Now, it's understandable that there is bound to be a bit of a delay, even though we're coming out of lockdown. Systems are now in place to deal with matters remotely. We've got video conferencing, etc. Hearings taking place by video link, working fantastically well at the moment. But it's working well now. But you've got to understand that there was a time last year from around March 2020 to autumn 2020 when systems weren't really in place to deal with hearings but remotely. So a backlog was created. So there is a bit of a delay in dealing with matters now. The tribunal is going through its backlog at the moment. But thank you very much for your question. Very topical, very relevant question for what the position is at the moment. Now, I know we've had a number of questions coming in on WhatsApp, and I do really need to answer some of those. So let's look at the next question that's come in. Let me read the question out. A viewer is asking, Salams, my question is, my wife went back to her home country because her mother was terminally ill. She overstayed her visa requirements due to mother being unwell and grief that she was going through, and also due to COVID. What can I do to bring her back to the United Kingdom? Now, two options really. Normally what you would look at in this situation is for her to make an initial out-of-country application again. So in the same way that if your wife had never come to the UK and you wanted her to come to the UK, you wanted to sponsor her to come to the UK, in the same way that you would be making an application for the first time for your wife to come to the UK, it's a similar kind of application that you would be making for your wife, because she's abroad, her visa's expired, so you'd make a similar kind of application. It's more or less identical to if you were sponsoring your wife to come to the UK for the first time. So she would have to fulfill all the normal requirements in terms of English, the A1 tested English, in terms of finances, which is normally dependent on you, the sponsor, and also make sure the accommodation requirement was fulfilled. So in the same way that you would be making a first application to sponsor a husband or wife to come to the UK, you'd be doing that again on this occasion. Now, obviously, slightly unusual thing here is that she did initially come to the UK on a spouse visa. She's gone back. She hasn't come back. You're going to have to explain in the application what happened in terms of, wife went back, mother passed away. That's why she wasn't able to come. The relationship between you and your wife is still subsisting. It's not the case that the relationship has broken down. So that's the only slight complication that you're going to have to address. But you're looking at making the application completely fresh. Now, for the benefit of our viewers, there are limited circumstances where somebody left the UK prior to March 2020, wasn't able to return due to COVID, and there's a lot of proof as to their attempts to return. If it was completely COVID related, there are circumstances in which she might be able to apply for an extension of a visa from abroad. I think that's going to be more difficult here, because what it looks like is that initially she doesn't come back because she's maybe looking after the mother who passes away, and due to, I think what you say in the message, that she was grieving and didn't want to come back. So she doesn't fall within, for people who've gone back, weren't able to apply, there is some flexibility where it's COVID related. I think it's going to be difficult to fall into that category, but I don't think it's going to make a difference. If it's the case you don't fall within that flexibility that's been introduced where people haven't been able to come back due to COVID, there's nothing to worry about. Make the application again as if it's a fresh application. All right, she'll be granted a visa, an initial 2.5-year visa. You'll have to extend again. She'll need to complete the whole 5 years in the UK. So you've lost the previous 2.5 years she's done in the UK. But look, all isn't lost. She is still able to come back to the UK and join you in the UK. I think your best efforts are going to be, if they're focused on making a completely fresh, a new fresh application for her to come here to the UK. Hope that answers your question. If you're not sure, please feel free to send me a follow-up question, or by all means, you can give me a ring live on air. Okay, had a number of other questions coming in. Let's have a look at that. Next question is, the viewer who sent the question in says, I just wanted to know how to bring over my husband to the UK. I have mental health issues. So could he come to the UK as my long-term carer? Is that possible? Now, so question really is about a husband who's abroad and how the husband can be sponsored to come to the United Kingdom. Now, in terms of a normal spouse application where you sponsor your husband or wife to come to the United Kingdom, that's absolutely fine. You're able to sponsor your husband to come to the United Kingdom as long as the normal requirements are met in terms of the English requirement, the financial requirement, accommodation requirement. It may well be that if you're unwell, you receive disability benefits such as PIP, disability living allowance, or attendance allowance, which may make it easier financially to sponsor your husband to come to the United Kingdom. The only thing I should say on this point is that the rules are designed for your partner to come to the United Kingdom, for you to live together as husband and wife. The rules aren't designed to call people over just as carers. It should be as your partner coming to the UK in a relationship where you're wanting to live together. So that kind of application can succeed if you're able to meet the normal requirements as to English, as to finances, as to accommodation. But it would be a normal spouse application that you would be making. Hope that answers your question. I know it's a general question and the answer that I've given is quite general. If you're not sure, please do send a follow-up question in and I will try and address your concerns in greater detail. Okay, let's look at the next question that's come in. Again, it's a delay-related question. We've had a number of questions on that's come in. Questioner says, I have applied for my settlement visa in February 2021. I still haven't heard anything in regards to the application. Should I call them and ask them what's going on? Now, the basic position with delay, and if you want to find out what's going on, is that unless your application has been in process with the Home Office for at least 6 months, the Home Office will not give you an update at all. So as a minimum, look, if it's an application submitted in February, you need to be waiting 3-4 months from the biometric enrollment date anyway for a decision. If you still don't get a decision within 3 to 4 months from the biometric enrollment date, yes, you can contact the Home Office for an update, but only where 6 months have passed since the application was submitted. So at the moment, if it's February that you've submitted the application, it's still early days. I think you just need to be patient and just wait for a decision from the Home Office. Hopefully, you won't be waiting too much longer for that decision. We've had a number of questions relating to delay. Things are, in my experience, going back to normal. So hopefully the delay will be dealt with. That, unfortunately, brings us to the end of the show. We'll be back next week on Tuesday at 8 o'clock. Until then, Assalamu alaikum.